taking action is the important part. And so I knew I needed to take action, and then also began to put a team together that supported me in this. So my stepfather happens to be an attorney, and I deputized him as a coroner, and he became part of my team. And with that knowledge and planning and ability, we were able then to do that in the way that we knew we would not jeopardize any other proceedings in this case. And once again, the idea of worrying about anything else really wasn't on my purview at all.
I would read the weekly paper. In Carroll County, we just have a weekly paper. And week after week, there'd be a statement issued by the Illinois State Police that was almost verbatim from one week to the next. We have a person of interest. The investigation continues. If you have any information, please call. And I thought, well, I think I read that last week and the week before. But be that as it may, my first understanding that this was really a big case came Labor Day weekend of last year. We went to the Labor Day parade in Shannon, and on the way there I see this banner, Justice for Jackson. And I'm thinking, I think I've seen something similar in Savannah. We get to the parade, and there's a family sitting opposite side of the street with a placard, Justice for Jackson. And then, lo and behold, in the parade, there was a group of 20, 30 people behind a large banner requesting justice for Jackson. And I told Matt's mom, I said, this is an organic grassroots movement. There's something to it. And there must be a lot of emotion that's building because of this. And it was after that that Matt and I started discussing what was going on with the movement towards any type of resolution of whether or not there would even be charges. And Matt expressed his concern that there was not much doing, so we started looking into the CORONER'S Act in Illinois, and it seemed that the ultimate remedy was for the coroner to actually go out if the jury finds that there was a homicide and that person has not been arrested by the sheriff or police. The coroner was obliged to go out and deliver the slayer, as the statute calls it, it's sort of antiquated language, before a judge. So I'm thinking, oh my gosh, Matt, under the statute, sounds like he's going to be commanded to actually perform an arrest. But then I did a little more research, and the Supreme Court says no, the coroner's not actually going to issue arrest warrants, and that's still a judicial function.
And so you reached out to him, or did you reach out? Who reached out about, hey, let's get together for this?
Well, Matt asked for help, and I'm sure realizing the magnitude of what's going to come down, and initially help on subpoenas, getting different agencies to turn over information to the coroner's office. So, he had to go and get our state's attorney to write up subpoenas for him and have them issued by the judge.
Once again, this case is very unique. Quite often the attorney that's working with a coroner could be the Carroll County State's Attorney. But he also needed to recuse himself in this case. And so this case was unique in that I reached to John and said, and it took quite a bit of nudging to get John to understand that I did need the assistance. And I think he got comfortable with the fact that I'm going down the right path.
And what's the purpose of the inquest? Is to satisfy the community as to what happened. So we realized our responsibilities is to how to present the evidence that we had, and what pieces of evidence were needed to fill in the gaps. So initially we realized, there's alcohol involved in this accident or incident. And the degree of alcohol was not readily available through a chemical test because the driver was released from the scene. So we had suggested to us that, it's really hard to get a conviction on driving while intoxicated without that breath test. And I said, geez, I'm old enough. I remember when we didn't have that breath test machine, and they still got convictions. So that was not, I wasn't afraid of that as a reason not to pursue an inquest. But we thought, I thought it's going to be very important to present the evidence, and in a way that the jury would understand, and in a way that would keep the jury's interest.
In the beginning, at this point also, we didn't know all the evidence. So our first responsibility is to gather it all. And we certainly knew some of the evidence because I'd been on scene and I knew what transpired there, and so all the crime scene technicians' evidence, I knew that and had that. The interviews we did not have at that time that had taken place, and much of the other evidence that comes from interviewing witnesses that were also part of this situation, and talking to the bars and getting video and so forth. We didn't have any of that at this point. And so all that needed to be gathered.
Was any of that evidence when you went in that you got were like, holy cow, maybe we kind of, was there a little bit of sense of surprise that state police, when you got this evidence, where you're like, holy cow, I can't believe they have this, I didn't know they had this, or you didn't really necessarily know the case was at that point?
Well, did we even know what evidence the state police had?
Yeah, we certainly did not know at that time all the evidence that they had.
Yeah.
But we're conversing with them, and some of those things I would learn verbally from the state police, and then, but not have the evidence in my hands. So I may know that we need to get that evidence. I think the way that they operate, and thank goodness they operate this way, they're very tight and strict with everything that they have within their purview. And so very reluctant to share that information with any outside source because at this point they're really taking their lead from the special prosecutor and waiting for that lead to be given. My responsibility is different than that. And I need to also do my investigation. And so in those moments, I'm pressuring the state police for that information. They're working with me to do that in the best way that they can. I think some of that information came to us a little bit later. We knew it was coming, but would come to us a little bit later.
So you guys were like the only two outside of that sphere that were investigating it, because like you said, well, obviously you have the authority to, But like you said, not every coroner exercises that authority. So in this situation, you guys are still kind of outsiders on having all of this information that you're about to present. Was there a point when you looked at everything and then listened to those interviews where you're like, maybe this isn't a good idea? Was there any point that crossed your mind where maybe we have too much?
Oh, heavens no. I think, from my perspective, if I can share it, I felt like the information was dribbling in. And we have a case to present, facts, and then, okay, here comes another transcript, or actually an audio recording of an interview. And we listen to that. Actually, in the late hours of the evening, Matt would stay up, I'd go to sleep. We're working together through the night, basically. Matt listens to this audio recording a second time, a third time, and each time he gets more information out of it. And we didn't have a transcript of it. So it's like you become more determined in getting this evidence correctly presented, but you have more to present that gives a better picture and fills in the blanks.
Yeah, I felt more confident as we got more evidence and it became a big thing. Actually, I think that helped our confidence that we were getting to the truth. And the people we're presenting to is that jury. And it's my responsibility to bring them the truth and not to have the truth watered down, not to be something that is a supposition by myself, but actually bringing the jury the truth of the evidence and allowing that evidence to speak directly to the jury. That's our job.
And I think one thing that Matt did that I appreciated that I would never have done as an advocate or as a lawyer presenting one side of a case, he presented an officer that had an opinion completely the opposite of what we thought the evidence presented. But we presented that because he was an officer that apparently had been an accident reconstructionist at one point in his career, and he just happened to have a different opinion. So Matt presented that opinion to the jury for their consideration. And the point of the inquest, I felt, was not to shade the facts one way or another, not to be argumentative in presenting it, because the jury is the body that has to make this decision. Now, we made it very clear to the jury they could ask questions, they could request information if they wanted it, and they took advantage of that because they were the body charged with making the verdict in the case.
Obviously, you had John's assistance for the law side of things, but for someone that was never a practicing attorney, the way you did it, because you mentioned it yourself about not just presenting all of the information from one side, giving the jury everything that was available, and one of that is Jackson's toxicology report, going through that information, and you remaining steadfast and just cool as a cucumber, you could put it, through the whole thing. Where did that come from with no practicing attorney experience? I know you said it was just because you were exhausted and sleep deprived, but how did you manage for 2 days to execute an inquest of that nature with that much on the line and just played it off as if it was just another day on the job, like you just had been practicing law for 40 years?
I wasn't looking at it as everything on the line. I was looking at it as, we have a few options here for my jury. And this goes back to the fundamentals of being a coroner, that we're looking at the manner of death. And could this be a suicide? So we need to explore that. Could this be an accident? And we need to explore that. Could it be a homicide? And needed to explore that. Could it be an undetermined that my jury may not be able to make a decision here in all agreement, because we asked the jury to be in full agreement within that jury pool on the final decision. So that could have come back undetermined also. We knew it was not a natural death, but I needed to present to them, and I was focused on that, to present the different evidence for those scenarios so that they could see it, ask questions about it, and inquire about it, and then really think about it and come up with that decision.
You could have presented it as, I believe it's homicide, so I'm going to provide all the evidence that supports homicide. Is that a choice of how you can present that?
As coroners, we're trained to be somewhat neutral and let the evidence speak for itself. If I have an idea, that idea could be wrong. But that doesn't mean I couldn't present that idea, but I better present it as, hey, this is my go at it. But certainly in this case, I wanted to remain neutral in every way that I could, because I wanted that jury to really get the evidence and then let that decision lie with the jury.
But more from a legal perspective, do you think that helped insulate the inquest from possibly negatively affecting a criminal proceeding? Do you think by presenting all the evidence?
Oh, I don't know how the inquest would negatively affect a criminal proceeding. If Matt was told by the special prosecutor or even the state police investigators, we don't think you should be presenting this evidence because we haven't fully developed our case yet. Well, that's really hampering the coroner in his performance of his duties. So I honestly don't see how that could negatively impact a criminal prosecution.
I think the system is meant to work together in a fashion, and this is a particular case where if I don't stand in my position and do that job, the system is not built to hand it off to a special prosecutor, hand it off to the state police, and still have it complete itself without someone else taking the responsibility to present evidence and to secure that evidence. Certainly the state police secured the majority of all the evidence, and they're the unsung heroes in this case. There was evidence, though, that we found in our investigation that also is important and came to the forefront. And it worked in this case. The system worked in this case.
We had a verdict by a jury of 6 people that ruled homicide as the cause of death. And we showed the special prosecutor, that a small town attorney and a small county coroner could get a homicide verdict. And this is how it's done. So, I'm sure the special prosecutor takes our transcript back and evidence that we presented and says, well, heck, if they can do it, why not proceed with the case?
Were you guys surprised they pled the 5th? Were you guys planning for that?
We knew it was a possibility.
I had no doubt in my mind that they would plead the 5th. I was surprised that they said anything.
I was hoping they'd speak.
You were?
Yeah.
Were you guys prepared if they did speak?
Mm-hmm.
So you guys were ready to ask them, huh?
Well, ready to ask the questions to bring out the truth.
But to have 2 witnesses plead the 5th in an inquest, how would you say how odd that is? What do you think that speaks to?
I think any attorney would tell their client to plead the 5th in that case. And that's what John relayed to me that probably would happen. I actually looked at it as an opportunity for them to be truthful with their community. And, and that could be important for them.
I thought the Illinois State Police did a phenomenal job of interviewing those two.
Oh,
I do too.
The interviews is what stood out to me the most, where I was like,
And they're both simultaneous interviews.
They are.
They're at the same time interviewing Matt, interviewing Amy the first day, and the same way the second day.
And it's real, and it is the truth, I think. And you can get the truth out of those interviews.
I'm kind of wondering, do you think Matt and Amy were blindsided by the inquest?
I'm sure they were surprised.
Yeah. I imagine they were surprised, yeah.
What do you guys hope comes from this?
I'll speak personally. Many years ago, I was involved in a jury case, allegations of sexual abuse in the state. At that time, I think accidentally withheld evidence, a statement that the defendant had made. And that went up on appeal, and it was reversed. The conviction was reversed. And I talked to the prosecutor at that time, and I said, what we do in this court, in this case, is going to live on long beyond us. We're going to be dead and gone, but the public will still remember what happened on this case. And we always want to do the right thing. And this Jackson Kradle case, what Matt did in bringing this inquest in such detail is going to live on long beyond his lifetime. And I think you're telling me that this case has a tremendous impact, perhaps coroners statewide, but what happened on this case, what was done, is going to live on long beyond our lives. And we hope it's the right message. And I think the message is that the system actually works. We've had our politicians tell us that our systems are failing us. Don't believe in the judges. Don't believe in election judges. Elections are rigged. It's so sad. And what's the purpose of the Constitution? You're protected by the Constitution. The work you do is specifically prescribed in our Constitution. Heaven help us if we lose trust in our institutions. And, maybe this is a civics lesson to our population, to our students, to our adults, that this is the way the system works.
There have been thoughts in our system to bring, all death investigation under, like in the state of Iowa, a lot of it goes to the city of Ankeny for autopsy and that part of the investigation. Here in Illinois, it's local in our counties. And I think there's a value to being local in your counties because you have a pulse and a heartbeat of your constituents who elected you to do that job. You know what's going on in your county, and you can also be the one to if you stand up in your county and you fill that role that needs to be filled, it's guaranteed it's going to be filled. When it goes outside of your county to some other entity, then the county doesn't know it's going to be fulfilled. And that speaks directly to the difference between the medical examiner system and the coroner's system. Yeah. Where the medical examiner is not a person that's going to fulfill the role of an investigation, where the coroner is that person to fulfill a role for the investigation. So an interesting difference, and certainly our responsibilities as coroners are much wider than the responsibilities that a medical examiner holds.